This is the
Yes,
similarity.
yes, I
There
mean,
is
you never
always
know.
going to be an issue or two.
Never know. Never know. Always.
And always you have to rely on these lies.
Yes, yes. Now, so many things. That's why we have to keep something in standby mode also. So I'm keeping my mobile also, Android phone, that also on hotspot. So in case the broadband of BSNL gives some issue, then I'll come on to that.
So that's
The other
more
one.
trouble, sir, because that creates a lot of echo. Two devices
I
in
know.
one room, and then you never
Yes,
where it is picking voice and creates problem.
I know, but this
Yeah, yes, we have to be prepared.
scenario is such that you can't help it.
So I hope everything is set now, sir, and we should start.
Yes, please. Let us start.
Shato.
Okay, sir.
Right, I think.
Good morning, everyone. On behalf of the School of Natural, Applied and Social Sciences, the Language Laboratory, and the Center of Linguistics of Maulana Abul Kalam Azad University of Technology, we warmly welcome you to the morning session of the 5th day of our FDP, which is titled The Art and Craft of Scientific and Technical Writing from A to Almost Z, which we are conducting in association with the Islamic University of Science and Technology from Jammu and Kashmir. This session, which is titled Patent Your Ideas, but How? The Skillful Craft of Filing Patent Applications, will be chaired by Dr. Yashwant Dev Panwar. Now I request my friend and colleague, Mr. Shushanto Koyal, to take over from here.
Thank you, Mr. Sengupta. For this session today, we are fortunate to have in our panel Professor Dr. Shukhendu Samazdar sir, the director of the School of Applied Natural and Social Sciences and the chairman of this FDP. Dr. Shankar Prasad Mondal sir, the convener of this FDP and the assistant professor in the Department of Applied Science. Dr. Dhanbal Kumar Sami sir, one of the distinguished panelists in our previous sessions and director of the Glorified. We are having with us Mr. J.P. Shaw sir as one of the guest speaker, and as our honorable resource person, we are having Dr. Yashwant Dev Panwar sir. So with that note, I would like to introduce Dr. J.P. Shaw, Mr. J.P. Shaw sir, and we are fortunate that we are having Mr. Shaw with us today to introduce this session. Mr. Shaw is the former regional director and deputy director general in the Ministry of Tourism, Government of India, and he is presently at service MAKAUT as the director of the entrepreneurship shell and the HOD of the Department of Travel and Tourism. Now I would humbly request Mr. J.P. Shaw to introduce the session before the audience. Over to you, J.P. Shaw.
Thank you, Mr. Kayal. I mean, it's a very lovely morning, and it's so nice to have galaxy of our resource persons and our colleagues from the university. And of course, having said that, we have Dr. Jaswant Dev Panwar with us, our main guest speaker and also the resource person today in this session. I think it had been a 5-day faculty development program which is being organized by our university and jointly organized by the Department of Natural Science, Applied Sciences, whose director is Professor Shukhendu Samazdar. I mean, he had been very, very, he's taking a lot of initiatives and a lot of efforts in this direction. Having said that, I feel that, the communication, the language laboratory that we have in our MAKAUT, communication in any way, whichever way you say, it's a very, very effective tool. Communication, whether it is verbal, whether it is written, it's one of the tools there is no alternative to it. We cannot have any compromise on that communication, because this is one area by means of which any one person, whether he is a scientist, whether he is a technologist, whether he is a teacher, whether he is a student, is able to express himself express himself to the person who is the person in front of him. And if he's able to express and if he's able to make the other side understand very, very clearly, that is the goal of the proper and effective.
I think we are experiencing some technical difficulties. Please
Sir.
bear with us. I request the participants to.
JP sir, can you hear us? Your voice is not audible, sir. JP sir, are you there?
No, his frame has frozen, so there must
Yes,
be
sir.
some difficulty over there. Okay, let's give him some time. He's going to reconnect, I'm sure.
Yes, sir.
Am I audible?
Yes, sir. Yes, sir.
Yes, sir. Please
I'm
continue.
back on my phone now. Sorry, the BSNL is as usual.
No, there is no reason for you to be sorry. I mean, this is part of life
This is
and
part of life,
technology.
and
Yes,
then
yes. Yeah,
I mean,
absolutely.
actually, what happens, Dr. Samasdar, when you are in a flow,
Yes,
the river is moving. All of a sudden, that stream is allowed us to
exactly.
say take a different turn. So that takes a little bit of a. Nonetheless, as I was saying, this patent thing, this intellectual property right, everybody has a right. Anybody who has developed something of his own, he has the right to have it patented. And this is one particular thing that in our FDP today, in the last day, a very, very important topic, patent and the how the subject itself from the beginning that we have that what we say the art and craft. Here, when you say for a layman art and craft, it means something else. But here it is art and craft of skillful writing from A to almost Z. I would say it is up to Z. Why are we saying almost Z? Let it be A to Z. This FDP program, we had a galaxy of other days. Also, we had very nice resource persons from different prestigious universities, from IITs, etc., from Jadavpur University. And today, of course, we have Dr. Jaswant Panwar with us, who will be giving a detailed, insight to all the participants here, including all of us, about how how one can patent one's ideas, and also the skillful craft of filing patent applications. That's very, very important. That's very, very important. How to go about in all the different countries of the world. As I was saying, there is a different form of. Normally, I believe, if I am not mistaken, the patent is for about 20 years or so. Of course, it is not for the entire life. After a certain period, the patent gets over. But around 20 years, it can be with the person who is the founder, who is the creator, who has taken up this patent of his this thing. I would like to briefly introduce Dr. Jaswant Dev Panwar before we request him to start his delivering his speech on the topic. Dr. Panwar he completed his PhD from IIT Delhi in management of IPR. He also holds degree of MTech in future studies and planning from Devi Ahilya Indore University, from Indore, of course, in Madhya Pradesh, and MSc in physics from MDS University, Ajmer in Rajasthan, specializing in microwave electronics. He is presently scientist F and heading Patent Facilitating Center, PFC of Technology, Information Forecasting and Assessment Council, TIFAC, TIFAC. He has been working for more than 23 years. My God, that's a long journey of his for PFC in different capacities. He contributed in evolving the important program of DST and also WOS, C, popularly known as Kiran IPR at all stages. TIFAC received Nari Shakti Puruskar 2015 for this program. His active area of patent oblique IPR related research are standards and patents. And forecasting future skills based on patent data, new foresight methodologies based patent information, AI and patents, etc. This telephone is another. So that was a brief description about Dr. Dev's journey in his career, and I would now request our Chief Resource Person, Dr. Panwar. As I was saying that this name, by this name I was not able to complete that time. This surname is very known to me. I used to have Secretary Tourism, Government of Rajasthan, Dr. Lalit Kumar Panwar, who was later on Secretary Tourism, Government of India also, with whom I happened to work. And as Dr. Jaswant Panwar was saying that not many people know about his surname. I would say, sir, that it's a very, very popular surname of Rajasthan, and we have a lot of senior bureaucrats with this surname throughout India. And I warmly, I happened to stay almost 5 years. I was posted in Jaipur, and I have traveled length and breadth of Rajasthan. I have traveled, of course, length and breadth of India also, being in the Department of Tourism, as my colleague, Mr. Sushant Kayal, was telling about me. I had worked with different offices of Government of India Tourism Department in various capacities. So I warmly and heartily welcome you today, sir, in our university MAKAUT, and it had been so nice that you had agreed and you had given us an opportunity to speak to our participants today on this very, very important topic. And I'm sure your insights and your deliberations today, with your level of knowledge in this particular field, will highly enlighten all of us. Thank you once again, and I now hand over the session to our resource person, Dr. Jaswant Dev Panwar. Please, sir, we are eagerly waiting for to hear your deliberations. Thank you so much, sir.
Thank you,
Mr.
Mr.
JP Shaw, sir. Thank you, Mr. JP Shaw, sir. But before we could go to the main session, I cannot refrain myself to add something more from Dr. Shamasdar's side, because as we all know, he has something more to say always, and which is always very much enriching for all of us. Please, Shamasdar, sir.
Thank you. I would say only one thing at this point, because that is, both this gentleman I know for a little while now. They have worked and they work in very serious positions, very senior positions. However, both of them are such perfect gentlemen, and with such immaculate manners, that is their first porichoy, if I may use that word, to me. So they are very close to my heart, because I have never found them with any chip on their shoulders, not with me, not with anybody. So it's a moment of joy to have Mr. Shaw Sahib, as we refer to him, as a colleague, to introduce Dr. Yashwant Dev Panwar, a person whose sense of humor is something which it matches only his his level of intellect. Dr. Panwar, please, Yashwant ji, shuru kijiye.
Thank you so much, Professor Shamasdar ji. And I should express my gratitude to Professor Shaw. So I saw him first time today. Thank you very much for a nice introduction. And I think I really don't know I deserve all that. But and then let's come to this particular program. I think this is A to Z, and I firmly believe that you would have all covered A to Z in last 4 days. So nothing is left for me, but what I will do today will add A, B, P, A, E, Z like that. So that's how, that's the role I'm going to play
You see,
today.
you were right away proving me right by such sense of humor.
I have to honor your. So, and then I'm again speaking to the program coordinated by School of Language and the language laboratory is very interesting to me. And when we look at patent documentation, this is actually heavily dependent on our language. So language plays a very crucial role. And my personal interest, before I get on to the patent documentation, and with the language school, Professor Samazdar, I have my personal interest in different languages. So I think I always, yeah, you wanted to say something, you can unmute and say. You muted, you wanted to say something. Professor Samazdar, you want?
I took note of it, that you have special interest in language.
Yes.
For future.
That's the lead for our future program, sir.
Oh, I really don't know whether for the program or not, but I definitely have interest, and I understand many actually. Indian language, some other also. I can speak, communicate. As I think Dr. Saw from travel industry. So when you travel different part of the country, you tend to learn and speak. So I learned many Indian languages at the same time. I learned the language of patent documents, also drafting patents. So let's move on to subject. So what I will do, if you permit me, I can share my slides.
Please.
Please, sir.
Sorry. I hope you are able to see my.
Yes, sir.
Yeah. So let me go to. I think this talk on skillful craft of drafting and filing and protecting inventions, and then very craftfully and with a lot of art, this title has been coined by Professor Samazdar. So all rights belongs to him for the title, but rest of the talk belongs to Taifak and me. See, if we say, let's begin. We are at the moment in phase unlock, sorry, as 5.0 we are in, not been updated. So at the same time, when we are unlocking from pandemic, I think we should unlock intellectual property rights also. And how we can unlock intellectual property rights? Let's try and learn how we can unlock technologies from patents and from patent documents. So somebody would have locked. So let's learn the game of locking and unlocking of your invention and others' invention, and making use of those inventions and patents, be it be yours or be it be of others, in making India Atmanirbhar, or a self-reliant India. So that's the call, clarion call by the Prime Minister. So let's work towards that. When we talk about, I am serving dual purpose, showing this particular slide. The idea when the pandemic was struck, that how do we monitor the spread of COVID? That's a mere an idea. And somebody, if you say, idea is there, yes, we all have mobile phones. When we can track our morning walk, when we can track our exercises, when we can track how many we have traveled, what is the other parameters. One moment. हाँ बोलो. हाँ बोलो. So if this device can talk, so idea would generally come. Yeah, why not this device can track the spread of COVID? Many people would have got that idea. But who could really succeed? Few entrepreneurs who pursued that particular idea. And their pursuance and perseverance led to this particular app, which have been downloaded by millions of millions in India. To really check, let's not go into other detail of this, but that's the power of idea, what we are saying, getting into a technology. But on the path of a technology from the idea, not many things are to be the whole mountain of difficulties to be traversed when you reach other side of the mountain with the success. A lot of technologies you put in. So how it has been protected, what can be protected through patents. And this not only actually writing is important, but before starting to write any patent specification, it's always important to understand key features and parameters in your mind before you really engage yourself in writing patent documents. So this thinking mind, because a lot of idea and ideas are flashed at any given point of time to your mind. Ideas getting flashed to your mind any given point of time. It is not possible to stop really breeding ideas in your mind. Breathing. And the important aspect here to breed those ideas to the next level and take concentrated extract of those ideas into technologies, convert them into the technologies, and on the path of conversion, there are tools which are available to you for protection of those ideas, patents, designs, IC layout protection, and very many kind of tools and systems available to you for protection of your idea. And really those protections would help you in exploiting those ideas. One moment, give me. I'm sorry. So we were discussing all these ideas, and I firmly believe that the period of lockdown and still working from home gives you ample time for creativity. Can we use that creativity in building new technology, new process, new products, etc.? So yes, we can do it, but the mere ideas will not be protected. Abstract ideas will not translate into technology. You have to do a lot of work. You have to apply yourself, go through a process of experimentation, go through a process of legal protection of your intellectual property rights. So that there are steps. So we will discuss those steps when you are struck with different ideas, what the patent is really. When we say patent, so can we look at patent documents from the angle of a technology? So any patent document definitely would cover at least one of these things. It can be a totally new product. It can be totally new process. If it's not completely new, then it is possible there is an element of improvement in existing products. There is an element of improvement in existing process. And all these improvement leads to some benefits. And those benefits are accrued because of a technical advancement in existing product and process, not mere look, feel, etc., etc. So if you have different advantages like look, feel, likings, then those need to go and shift it towards other forms of intellectual property rights. Those protection of those ideas could be through other forms of IPR, IPS. But if we talk about patents, it has to be a technical advance in your product. It has to, or it has, there has to be a technical advance in process. So you have to see your work through the eyes of technical advancement and newness. That is very, very essential before moving forward and thinking about protection through patent. Huh. Then we will not be answering these questions: who owned the patent, where it is valid. That's not today's. So patent documentation consists of legal terminology, consists of technical terminology, and many a time uh, when you try to describe devices of future, products of future, processes of future, based on your innovative work, there's always expression in the language of indicativeness, what it indicates, and how do we capture what we are indicating, what the whole technological development which you have done, or a invention which you have done, would lead to benefit to the society, benefit to the scientific community, benefit to the industry. And when we look at those benefits, most of the time inventors get carried away with those indications. Most innovators get carried away with those indicative those precursors of benefits in form of monetary benefit, in form of a technological benefit, in form of any other benefit. They get engrossed with that and lose track of very importance of each step in explanation of those technical advancement. An adequate amount of experimentation, and validation of the technical concept which are part of those innovations. So we have to focus on validation with data, validation with iterations of experimentation of the same for the same invention, be it be product or a process. So generation of those data, understanding of those concepts, if required, try and omit all uncertainty or any hidden factor which is not explaining your invention in scientific manner. You have to go and work on that before really go and start writing, start protecting your invention. So that is the homework or the side work along with doing a research, converting your ideas into new product or process. So all those steps are very, very important. And how do you perceive outcome of your research? And how do you express, as Professor Saw made very important point about expression. Expression is a very powerful tool to take control of a situation before you and before others and in jointly also. And we can look at, for the same thing, different people would express differently. And when different expressions are there for the same thing, the taker of that information definitely would perceive that particular product in entirely different manner and will build an opinion and deal with those products with that opinion. So that would play a very important role in gaining success, attaining success, or losing the battle. Let's look at this. All you're familiar with these two examples here. To explain, optimists always would say the glass is half full. Glass is half full. And the pessimist will say the glass is half empty. So this world do not have only these two kind of people. There are other category of people who think differently in this world. And they are actually a leader of a change or agent of a change. So the same glass was explained by our Honorable Prime Minister that this glass is half filled with liquid material, water, and the other half with gaseous material. So the glass is fully filled, half is filled with liquid and half is with gaseous matter. The glass is always filled. So that kind of expression would change an opinion of yours, opinion of a people about what is available in this glass. If that particular gas in the other part of this glass is very important, let's say this glass is sealed, you have good drinking material, liquid material, maybe orange juice, which is half filled, and the other half part of glass is packed with pomegranate smell or a material which is having gaseous material, which can give very good fragrance while drinking that orange juice. Maybe with pomegranate or anything which people like, which can give a different flavor. That half-filled gaseous material can make a lot of difference in the same glass. all of you were aware that if you close your nose and eat apple, it will taste like potato. So smell always matters in enhancing taste. So can such an gaseous material be filled with this half glass, which can result into some kind of an invention? Yes, definitely it can be. So that's why language is very, very important, but that's not ultimate. Language would be important, and it would be very important tool to capture your understanding. To capture your understanding. Sorry, there was an interruption. But let's say I was talking about adding some kind of innovative features there. But look at how the patent attorney, while drafting a patent application, would write this half empty or half full glass. The patent attorney will say liquid H2O bisect an open cylindrical vessel and whatnot. He will add the description of a vessel, etc., in those claims, and all subject to if that is novel in totality at that point of time. So I'm not getting into the novelty aspect of it, but I'm just trying to explain the way we express the same thing in patent documents and why it is essential. Even having that kind of a description from scientific point of view, it says liquid H2O bisect an open cylindrical vessel. And here, I'm industrialist, looking the same example from point of view of utilizing this particular invention and read, then definitely I will read the patent document. I read the patent claim. It says liquid H2O bisect an open cylindrical vessel. Oh, I say, I'm free to copy this. They say, why? How you can copy? I have a patent. I'll say, go to hell. I'll copy this. And why I'm getting idea and so confident of copying this? Because the language used here is a faulty language. I'm saying cylindrical vessel, and if you carefully look at this glass, it's not a perfect cylindrical shape. And what shape I'm using is entirely different from the cylindrical shape. So the use of word cylindrical vessel is absolutely dangerous, contagious in losing patent rights. So that is how use of each word matters. That is how in patent document, use of each verb, phrase, expression matters. And all those expressions which you have on the claims are supposed to be supported by technical data, technical advancement, different embodiment of performing the inventions. Wherever required, you have to give engineering drawings. If your invention is a biotechnology, you're supposed to submit gene sequence wherever necessary. And in support of your claims, right kind of data to be generated. And data generation should be directed towards what really you were claiming after having invented particular thing. So if you are working in a chemistry, you may work in ranges. If you're working in a machinery, you may work with a power, you may work with dimensions. But when we talk about engineering inventions, those are dimension agnostic. If any mechanical device, dimension would play an important role, but not if we talk about a wheel. If it's a wheel of a 1 inch or a wheel of a 10 feet, wheel is wheel. So if we really something which is round, we want to protect, dimension will not play a role. Dimension of the wheel will start playing the role in a holistic system. When we talk about the complete system and essentiality of those dimensions in the functioning of that particular machine or a complex system, then those dimensions are important, but those also can be put into ratios of fellow component of that particular machine. So there are various ways and means where you can categorize your information, you can compartmentalize your information, and then really you can get a very good piece of patent through those concepts and features. But don't get confused with what is the outcome which you achieved is an invention. Yes, definitely that is an invention. But when we think of protecting through patents, it's utmost important aspect, how we are able to achieve that, and all those steps, all those technical steps which enables the working of inventions are the key element which need to be put into the patent documents. So rather focusing only on an outcome, each of those steps which enables the technical enhancement in your product and process. And we have to map. And there are techniques to map that. So we have to see this through technical perspective. At the same time, patent is a techno-legal document. We have to legally correct also. So language which we use should be sustainable in the court of law, because real testimony of patent protection would be when it is tested in court of law, when it is tested in court of law for the infringement. And here I would like to categorically mention that value of patent is not in protecting your invention through patent. Value of patent is really enforcing your patent. If 100 people copy your patented invention and put the product in the market, and if you're not able to stop them, then the patent doesn't have any value, no value at all. So value of patent is, or in other terms, value of intellectual property rights in all sense is in enforcing intellectual property rights. So real value is there. Sorry. So that is how the front page of any patent looks like. There's certain type of details you have to put. All you writing nice papers, and you had very many sessions on. But I'll not. And say, I would like to quote something here. If you have the idea, getting idea doesn't call for much thought. Any damn fool can get two ideas. What is tricky after you got two, three, four, or every day? But what is important? Choosing one that will do. Means from all your ideas which are hovering in your mind, choosing few ideas which you are converting into. So mapping of all your ideas and try to convert. So I think I have already covered these important steps from idea to success. And I think today's topic is not up to all 6 points, but today's topic is up to point number 3. Getting and converting patents into patentable inventions. So as we already
We will be back soon. Sir will be joining back soon.
Please stay connected. Sir will be joining back soon.
I'm really sorry for short interruption because I had to attend. There's some last date cases. So I think all you may be aware that patent is not the only form of intellectual property. There are other forms of intellectual property rights in the school of language. The copyright, very, very important tool. Even if you achieve in a lab of natural language laboratory, if you can really have devices which can translate from one to another efficiently, those technologies also subject matter of patents. So we talked about this patent. Let's get into some kind of basics. Why it is granted to you from the government? Because you're disclosing your complete invention to the government. And a lot of time apprehensions that are there that patent office will leak your ideas, patent office will disclose. So there's no question of leaking idea. There's a formal system of publishing your patent document. So when you publish paper, everything is published. When you file patent document, if you pay fee for publication, then it can be published early. If you don't pay fee for early publication, it is published after 18 months. So all the patent documents or technical details which you write into the patent documents get published by the patent office and is available to the whole humanity. And in exchange of the disclosure which you make to the government, complete technical detail, and that detail should be sufficient enough. So when Dr. say art and craft, so between art and between the craft, the completeness has to be there. That anybody who is skilled in the art, who read the patent document should be able to perform the invention and should be able to achieve the outcome which you describe if he has all wherewithals to perform that invention, let's say ingredients, the device, those environmental conditions, processing of different material, signals, and instruments. So if the person in a state of art person skilled in the art generally means who can really understand and able to appreciate the subject. May not be necessarily the expert, uh, having high expertise, but who is able to understand those technical steps which are described in the patent document. So when we say art and craft of, so the art and craft should not be too encryptive that people are not able to decipher, people not able to practice that particular invention. It has to be clear, clear and in detail. And if there is a comparison between prior work and the post work, then definitely, yes, it is essential of incorporating all those technical details. And not only one example, but if you put in different examples of performing your invention, in the patent document that enhances value of your patent document, that enhances stronger protection to your claims or a concise protection which you seek. So disclosure is very, very important. And then there is a format of disclosing your invention in patent document. So you have to put your technical thing. And not go into this. This is an exclusive right to prevent third parties from making, using, selling, offering for sale. But what this exclusion is all about is the entire document, whatever you describe in a patent document is debarred by the law for anybody to make, use and sell? No, not everything. You may have 100-page description, you may have 1,000-page description, you may have 1,000,000-page description of your invention. It is not in totality that everything is debarred. What essentially is protected in 1,000-page or 100-page or 30-page or 40-page patent document is your linguistic expression in the form of patent claims. So there's a portion in a patent document called patent claims, and the protection is available to you. The features of your invention you have claimed in those claims as novel, features in your invention you described, your language started to play a very important role there. The parameters which you put there, the fixed parameter, you put ranges there, that makes a lot of difference when you are enforcing. So the claim becomes very, very important part of that whole document. And now in your patent craft here, if there is a mismatch between claims and the description which you have given in patent document, that would be questioned by patent office. In anything, any novel feature of your invention or newness in your invention, which you have covered in variety of example, and you missed in your claims, it means you are disclaiming those technical details which are not part of a claim. But document is a 100-page document and claims may be within a page, a para or two. It is not necessarily a summary of that particular document, because to write a summary of a complete patent document, you have a other section of a patent document which is called abstract. So in abstract, you are summarizing the whole invention, maybe 150 word or maybe 500 word max, you can put it. But the summary is different and claims are different. Claims, you draw the boundary of your protection. So you have to write two different things out of the complete disclosure of a few tens or a few hundreds, few tens of pages. And that's where the understanding of a concept behind that particular innovation is important. And I firmly believe that inventors are quite excited about the work they have done. They're capable of listing all those technical features. Having done that, putting into the legal language is a challenge. And to get that edge or art of putting things into the techno-legal language, what I would recommend to the interested people to download few patent documents and start reading them. And I remember initially when I started reading patent documents, and many a time I rushed to my supervisor at that point of time. It's the same thing has been protected in 2 patent document. It looks like that. Oh, then he saw that. Oh, no, 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 no. He pinpointed the difference in 2 inventions and 2 protections, 2 patent documents. So those differences may be very fine differences. We have to enhance our understanding to that level of making differences in previous invention and your invention, and drawing clear boundaries of protection in a concise manner, and to be written in that particular format. I'll not go into this. It is for 20 years, and after 20 years, it falls into public domain. So we have already discussed. But to be able to, what patents you can find is for new invention, for the novel invention. And when we talk about this newness or novelty, it has to be globally novel. So you had to look into the global patent and non-patent literature and claim your component of innovation with existing and draw the different line. And that will help you in drafting and filing and writing your patents. Though you may yourself be writing patents, that may not be advisable if you're not having adequate experience, but still you write and refer it to patent attorneys or patent writing professionals for vetting, and with their inputs, you can go and file. Then the second concept is inventiveness. Difference between novelty and inventiveness. Novel means it reads on existing document or knowledge one to one. And when we say inventiveness, it's the mosaic of technical document indicates your invention, clearly indicates your invention. And this always very subjective and case to case basis can take different turns. But the inventiveness is defined with the mosaic of documents or more than one document if it's indicative of your invention. So you have to negate and differentiate from those indications which those documents gives in achievement of your invention. So before start writing these, you have to clearly establish novelty wherever there's a one-to-one matching from previous document and mismatching. So the mismatching need to be identified. And in inventiveness, in the mosaic of documents, those indications to be written the left side, all from those documents, which you can feel that may be, and then how you achieve those technical advancement, those features and those differentiation and novel differentiation, you have to put in a piece of a paper in a tabulated form, or you can make a matrix of that, which would assist you in drafting patent document, So that is how you should do as a scientist homework before going to IPSL or patent attorney to protect your invention. I'll not go into these. So what constitute, I'll share these slides with Dr. Samazdar. Let's not go into it. But there are very many key features. The Patent Act says there's certain kind of inventions which are not patentable. So any machine which gives more than 100% performance, or perpetual motion machine, are not patentable. Now, a lot of people comes to my office. They say this machine, this is a perpetual motion machine. It works without input. That will never happen. Scientifically, if you put any proposal in the patent document or any other forum that your invention works, there's an output without input, or it has more than 100% performance, it would be denied patent protection. So what is the option here in such cases when you face these realities? Because what happens many a time, inventors are able to achieve some results, but are not able to understand technology or science behind that. So really, then I would advise can take expert help. You've made a machine which is running. Now, important aspect here to identify what is the input. Is the gravity input? If gravity is input, but then you have to total all anti-gravity movement in that particular machine to make it a perpetual one, and how the total energy input is more than energy output to be calculated for those kind of, and that has to be in scientific manner or a technical manner. If you put load on that, it will work or not. So those kind of additional experimentation you have to perform. The moment you are able to identify those inputs, then you will be able to protect that. Otherwise, it will be called frivolous inventions and inventions which are contrary to well-established scientific laws. So here I'm not talking about law per se, but the natural laws, like Newton's law. Till we prove those laws wrong, anything contrary to those scientific or natural laws will not be patentable or protectable. So that's where we will have to find solutions, develop understanding to a level where we really can differentiate from falling into a trap of like frivolous or that kind of invention, which is cannot be imagined within the present scientific framework. But it's not all about unexpected results. But if we are able to scientifically explain, yes, definitely, that becomes a there are some devices, and here again the skill of writing patent documents would help you in your thinking process. See, any device whose commercial exploitation or a primary use, see here you have to read it very carefully, primary use of invention, there may be a secondary use. So if the primary use of this invention is contrary to public order or morality, then it cannot be patented. So if you have a knife, you can cut fruits and you can cut your nerve also, or you can damage somebody's bodily damage you can inflict using that particular knife. But when you invented a knife, what is the primary use which you describe in your patent document or invention disclosure. That's very important. That plays very important role. Very important role. Let us say you have made a very good cutter which can cut almirahs, which can cut iron structure. But if you saw the primary use of that cutter is cutting ATM machine, patent office will say patent cannot be granted to you. One month. So to be able to protect what we have invented, we really have to look into the patent system, have to learn the art of putting and projecting our invention and our work in a perspective and framework within protectable limits, protectable identity, protectable methodology. Many scientists which I meet have discovered this thing. I have purported this theory. I have written this algorithm which can solve a big problem. I have discovered this microbes which can actually treat the water in very short time. Even eats it. It removes bacterial contents, or it uses bacteria. And I have discovered this material while digging into deep well, and this material is very useful in computer chip. So now if we project them as a scientific principle or project them as abstract theory, and let's say this one example from this abstract theory, I would take at the end of my talk, 6 boys from Debrugarh University. 6 boys from Debrugarh University wrote a paper in a mechanical engineering students wrote a paper on converting cyclic motion into some elliptical or specific. So how they conceived the conversion of motion, and they wrote a paper and published it. Now that was an abstract theory which they purported. Now we said, if we go and try to protect that theory or abstract idea, cannot be. Can we, based on this theory, can we evolve a device? And when we evolve a device, the device should have some use. Can we put that particular device to some use? Those boys worked on that idea and converted into some device. We'll see that later. We file patent for the same. People says the patent has to be filed before publication. But in that particular case, we did not seek protection for what they have published. We filed patent for the next level development, which they converted that idea into devices. And device was entirely different entity It's not mere implementation of those abstract ideas, but little more than, see, at every step of implementation of your idea, you invent. It is not that once you get an idea, you invent. So once you try to convert your ideas into product and process, each step you have an inventive feature, and all those inventive features to be listed, overcome from these non-patentability issues in patent trick. And why I have taken this route of this I have taken from my experience, that non-patentable invention and a crafting, art and craft of patenting. Many inventors comes to me and say, I have made a nanomaterial. I have made polymorphs. I have extracted pure form of curcumin or any natural this thing. I say, sir, you've done wonderful work, great science, great technology. You're able to make nanomaterial of iron. Great, sir. He said, I want to protect this nano powder of silver or iron or any other compound. Then we have to say, sir, sorry, new form of known substance is not patentable. I say, nano, there are very many patents in nano. Now, here again, art and craft is very important. We have to extract here what we can protect. Now we sit with the inventor and ask, sir, material of this iron or this particular thing, converting mere changing dimension of particle size is not patentable. They say, no, it behaves very differently when particle size is very high. If I have a nanomaterial, the whole material behaves differently, so that's a different material. But in patent parlor, they say, no, it's a new form of known substance. It is not patentable. So what can be patented here? How do we identify our work? There's no possibility, or is there any possibility of patenting this new form? Yes, there is a possibility. So what we have to read this kind of clauses in contract. Unless such known processes results into new products or employ new reactant. Now let's say what is the new product? You're doing nano encapsulation. So those drug delivery vehicles becomes new. If you need a process, specific process to achieve those nanoparticles, not a standard process, be it be chemical process, be it be physical process, any machine which you invented to make nanoparticle of that particular substance, be it material, metal, whatever it is. So the process of making nanoparticle, if that is new, that can be patented. After making nanoparticles, say you have a technical textile, you have a nano coating on your textile material which absorbs dirt and all. So you have made the technical textile by nano coating. That becomes a new product. But the nano particles of that material which you have coated, it's not a subject matter of patent. So within the framework available in a patent system, we need to identify. And in most of the cases, I wouldn't say that you take all the decision. Wherever there is a confusion, I would request you to take professional help. And when you go for a professional help, don't be shy in disclosing everything. And the relationship with patent professional and you, I would rate, would be like a doctor and a patient. Though you're getting a patent, but treat yourself as a patient in that case. And you're going to a doctor who gives you professional advice, how and what can be protected in work which you have done. So you have to run through all these non-patentable items, you run through all existing art and inventiveness and all those issues. Then carve out your space. Then paint your ideas in the form of patent document. Then again, another section in a patent, I don't want to be negative in mentioning this example, but this actually facilitating me to clear some kind of understanding from the situation which you come across day and night when you invent, you have a novel work, an inventive work. It says mere discovery of new property or new use of known substance. Be it be known process, machine apparatus, unless such known process results into new product or employ at least new reactant. So if again here also, see if it's aspirin is used for some purpose, blood thinning, if it treats a heart ailment, tomorrow we may find new use of this aspirin. So new use of known drug will not be patentable. Okay, so when we have paracetamol, or which treats fever, we'll say whether it treats corona fever or मिलन थोड़ी देर में आओ. And the interesting story behind this. One of the inventor in Ludhiana, what he did to separate the cream from curd, he used a washing machine. He put the curd into washing machine and he start the washing machine, so it's rotate, and cream will come, and then they will take and heat it and make a ghee out of it. He said, I want to patent this process where I have used a washing machine to. This is the all known function, how it can be. But yes, if you really want patent for such devices, you have to do improvisation there. Create a mechanism which can, when the cream is settled at the top, it takes out the cream and then it heats up and convert into a ghee. You can make a complete device out of that washing machine into ghee separation from the whole process of ghee separation from water. Yes, patent is possible, but you have to apply your mind and you got to write your patent document. So that's where art and craft, writing patent documents would help you getting protection for some time felt in explain non-patentable. So we have to, and again, another section, is mere admixture, which result into aggregation of a properties of a component. It's not patentable. So 1 + 1 is 2, no patent. If 1 + 1 is more than 1, definitely, yes, patentable. There are examples. You put sugar in water with a color additive. So color will be colored. If you remove sugar, it will be there in that. That gives good look, good taste. This effect is an additive effect. So you have two different known thing, and you made an admixture. There's no reaction amongst them. Now you have carbonized it. It has a different property, becomes patentable. Mere arrangement and rearrangement or duplication of known devices, each function independently of one another in a known way. And in engineering colleges or technical institutions, most of rejection of disclosure moving forward is based on this. So, ये तो सबको पता है. Everybody knows this. But we have to read this very carefully. When we arrange and rearrange known devices, and the complete function of those different component is possible because of interdependency of special function of each devices. And function of one component is altering the function of other component in the whole scheme of arrangement and rearrangement of known devices. The moment you are able to generate interdependency of function and achieve something out of the combination of known devices. See, if we take an electronic circuit, you have a few components which you put in a different manner. You have a transistor, you may have a diode, resistor, capacitor, PCB. What else? So you have turquoise. So these all known components, but you make different arrangement and rearrangement, means you connect them differently. You have a power combination which you put is differently, and even you make combination of transistors in that particular circuit in very many textbook or innovative manner, those connections, which achieves a yield result which you purport and outcome of your device. Yes, so all devices are known, all components are known, but the arrangement and rearrangement, if it leads to new device or a new function, definitely it can be. But if it is not a new function, then it cannot be. But the new function or a function of those devices, sometime along with the application can be protected if application is unique and specific. But in many cases, the application of this new function which you are achieving can be protected across the different type of devices. Let's say, for example, you have remote control, the infrared remote, which you can control your AC, you can control your TV, you can control your fridge, you can control your car AC. So there are different applications of same device, but the insight or the line of sight use infrared and communicate with the device and pass on signal. That if that is, the devices are known in both sides, components are known, but you created a mechanism where you can control the other device. Means you have created independent functionality in using those components. But then your patent is irrespective. Then you don't say that my patent is controlling AC or my patent is controlling TV using this infrastructure. Let it be broad and cover everything. So the mechanism which you have invented, if it is copied for other application, still you are protected. So don't limit yourself or a protection of your invention by these application limitation. So that's where when you write a patent document, you have to be careful in limiting yourself, limiting your claims, limiting your claims. So if you've done method of agriculture and horticulture, then again, it will not be patentable. So you may have a very good method of growing mushroom at home. That method of growing efficiently will not be a patentable subject matter. So any process for medicinal, surgical, curative, or any method of treatment of human being or treatment of animal to render them free of disease or to increase their economic value, that of their product, will not be subject matter of a patent. But here, earlier, plant were also included. Now, any treatment of a plant which increases economic significance of the plant material or output, again, that can be patented. That process, or means treatment itself is always a process. Treatment is always a process. So that can be patented. So if you're performing surgery, if you're treating human or animal, no. But here it does not debar everything. See, if you have invented a surgical device, that will not be coming under this restriction. So the surgical method, the way you perform the surgery is not patentable, but the instrument which you invented to perform particular surgery is patentable. When we say the medicinal or therapeutic use is not patentable, but if your drug which has therapeutic effect, the drug is patentable subject matter. Process of making the drug is patentable subject matter. That the surgical instrument is patentable. Process of making that surgical instrument is patentable if that is new. Any machine which is making that surgical instrument, again patentable. And any process and component of that machine which makes the surgical instrument is patentable. Now in whole chain, we have to identify where my work has created new invention, where my work has created impact in those machine and devices. So those we have to write. Those we have to write in patent document and explain explicitly those documents. Here it says plant and animal. So we cannot patent plant because for that we have a separate registration system. Animal, we cannot patent in India. But it says other than microorganisms, yes. We can protect microorganism, but we cannot protect seeds, we cannot protect varieties, any species, or anything which is by essentially biological process, or any process also cannot be, by essential biological process also cannot be patented for production, propagation of plant or animals. It cannot be. But the hope here is microorganism. But there's a catch. If we look at the fundamental of patents, it says it has to be new. So, and then anything is discovered, it's not patentable. So this microorganism will also be subjected to that particular class. So if you are isolating microorganism which is existing in nature, it cannot be protected. But if you're genetically modifying the microorganism, definitely genetically modified microorganism is patentable, provided it fulfills the three criteria of novelty, inventiveness, and industrial applicability. So that new microorganism which you have genetically modified, you should be able to associate some constructive use of that microorganism, be it in the process or a new product. Then again, that can be protected. Okay. Here, a lot of mathematicians complains to us that the mathematical method or a business method or algorithm, those are not patentable. Then they say computer program also cannot be patented. But all of these, if the result into handle the functioning of some hardware, some machinery, some component, some material, then they becomes a subject matter of patents. Like you have developed an app, which is IoT. You can, for IoT, you're controlling all the devices of your house through app. The computer program interact with different sensors, different devices. That's a subject matter of patent, though it's a computer program, because this enhances technical function of devices. They need to interact. There's arrangement and rearrangement of different hardwares. That becomes a subject matter of patent. But the mere extension of those same function may not be patentable. That if you provided there is a different functionality in the system. But most of the time, confusions are there. If you have a big machine, you say, I have made this improvement. But everything has not changed. The identification of change you have made in that machine is subject matter of patent. Let's look at semi-automatic and fully automatic washing machine. Each washing machine has a drum. Each washing machine has a swinging mechanism. But in one, you have two drums, and in other, you have one. Now, where is the invention? You say one or two drums are made in one. Now, you have list features. What is the problem with semi-automatic? And what is the advantage of a fully automatic? That's very clear to everybody who looks at it. But what were the technical difficulties in achieving the fully automatic? As an inventor, as a patent protector, you should identify those technical difficulties which were existing and you have overcome those technical difficulties. You are able to handle in one drum both the operation, how it is possible, what problem you solved. And that can lead to, and definitely those are patent subject matter. I'll not go into all these not patentable, but still we can find something patentable. Atomic energy related. This again, now you have a radiotherapy, the machine for doing radiotherapy which use cobalt. Again, it is radioactive material, whether it will fall into atomic energy. Yes, it will fall, but it's maybe possible with the permission from atomic energy, the kind of use we are putting that radioactive material. So it's again governed by Atomic Energy Act, whether that is allowed or not. And these were done for the different purpose, technical purpose and need of the country, that we wanted to use technologies relating to atomic energy more freely and with lesser restriction of patent protection. All these things are time to time may change or may not change. But you really have to look at radium. If you put in your watch to see the time at a night or in a dark, is it prohibited for the protection by Atomic Energy Act? We can go and find patent document. Oh, such patents are granted in India. Yes. So graphite, if you're using in a pencil, can the pencil be patented? So how you have made a pencil or pencil as a product of first time, or you had mechanical, the pen type pencils where you insert those graphite lids into those pen and manufacture those devices. So those devices, if you don't use a graphene, the devices are independent of this graphite. Or there you can put in any other material by which you can write. So then you have to de-link those instruments from the raw material or material which you use to perform particular function. So when we say art and crafts, linking of a material, devices, application is also important. At the same time, de-linking of applications, materials, raw materials, devices are also essential. When I say both are essential, say, how do I meet two essentials? And that's where your craft or art of drafting patent or writing patent documents would help. And that can come to you when there's no better teacher for learning art and craft of writing is reading. And that reading you have to put some time and spend time in reading patent documents. That would benefit in improving your. So I'll not go into this. Who can file, but see, as a employee of institute, you have to assign your invention to your institute. Institute is all, if institute is a legal body, may issue emergency when colleges are there. I'll not go into this, but there is a documentation requirement for patents. Okay, so what are all documents required for filing patents? One covering letter with the request to the controller for accepting your patent application. Then there's a well-drafted form which is called application form. So when you apply for different posts, different positions, different courses, you always see some format within which you have to pull details. So the form 1 is a form where you do assignment of your invention to the applicant. If you yourself is applicant, then you insert your name as an applicant. You give a title. Title has to be not more than a few 15 words or so. And that should be appropriately indicative of your invention. Then inventor's name, address, applicant name, address, etc., to be filled into form 1. Means form 1 is an application form for getting patents. The second important form is form 2, which is if you have completed your invention, then you file that form 2 as a complete specification. If you feel that your research is not complete and you're afraid somebody will copy it or will come up with the same research and you want an early priority date for your work, then you can file provisional specification, and provisional specification may not be necessarily supplemented with claims So within 12 months, you have to file a complete specification. And then Form 2 is the format within which you make complete disclosure of your invention. And you write your claims, you put your abstract, and even you put your drawings in link with this text and claims both. And if gene sequence, the sequence to be submitted as a part, that will be considered part of this specification. Maybe in the pen drive, no, or the CD, you will submit those gene sequences. That becomes an integral part of this. Form 2 is as a complete specification. There's the three things to remember. First is the front page of this Form 2 has to be in a prescribed format where you write some text is given in the form. You can download these forms by clicking here. Then preamble on the first page. If you're filing provisional, you have to write that preamble. If you're filing complete, you write. So on the first page, you have prescribed information. From second page onwards, you have different component of this form. So you define the area of invention, then you background of invention, then you put summary of invention, and then you put different examples of performing inventions. So when I say different examples of performing inventions, so if it's a mechanical device, you may have a different embodiment. If you have a chemical invention, you may have different processes or different settings, different experimental settings. If you're bio, you may have a different examples or different biological material use. So those can be in a fragmented manner or in a continuation manner or a complete manner. And then your claim would start always from a new page. So if you're the component which I have listed are finishing at a half a page, but when you start writing claim, it has to start from new page, where if you're alone as an applicant, then say I claim, or if you are more than one applicant, then say we claim, and then you start writing your claims. And then these are forms I'm not going to certify, and these copies. Provisional and complete, we have already talked. So this content of specification I have already discussed. There has to be title, the field of invention. So the title would come on the front page, followed by preamble, and then you go to the next phase, next page. The next page start from field of invention, then background, object, summary, brief description of drawing, detailed description of invention, and then it should describe the nature, etc. Then claims, which I said is the most important part. And again, these claims supposed to start from. So you have first break here for field of invention to start from a fresh page, and claims has to start from fresh page. Then abstract has to be on a separate page. Then fees, etc., etc. And there is a special format for putting drawings. The right top, you write the title of drawing. Then at the bottom right, you write applicant or agent, and the left inventors. So there's a prescribed format for putting those technical drawings. And there are some essentials, which if you're using a biological material, you're supposed to disclose the origin of a biological material. So when I say biological material, maybe microorganism, maybe powder of any leaves. So any biological material, dead or live, you have to give an origin of those biological material in the patent document. If you are using some microorganisms, then you have to deposit those microorganisms to internationally recognized or authorized depository authority. Then only then those existing number to that particular material you have to quote in the patent document. And those materials should not be publicly available before the filing of patent. And in India, for depositing, we have IMTEC and NCL Pune, it's two depository authorities. I think these documents we have covered, I think it's already 12:26. I'll just take one example. Now this is a simple device. Then this again is done in Kolkata, SN Bose Institute. I think some of the people may be seeing this. This is by Dr. Paul. What he is doing is a non-contact measuring of body parameters. And initially it was designed for measuring bilirubin level, and then extended for measuring hemoglobin. So hematology can perform, and then it's also for measuring blood oxygen level. And all these three parameters are measured without contacting body. So now, see, we filed patent. So patents were filed many years. But now, in the COVID situation, can you do some more improvement and you can measure the oxygen level, non-contact? So all those things. Now, if we have an oximeter and at a railway platform or at an airport, we are able to measure the oxygen level of people without touching them or from far off level. That can help us in spreading COVID in addition to Arogya Setu. Can we make these devices cheaper? Can we have innovation there and file a patent and protect? This is the device I was talking about from Dibrugarh University, that those paper which wrote in a mechanical engineering converting machine. So that paper was converted to this device which can pick garbage from different surfaces very efficiently. There's no time for going into technical detail of this particular invention. And this we filed patent. Now it is almost, we have responded to queries from patent office and may be granted at any time. And simple thing can play a very important role. And having innovative in the corona phase, it's not relating to patent, but I just wanted to show this, how creative people are. People have made corona saris with those images and corona with mask and all. So there's a design, there's innovativeness is there in people. I think here I would like to stop. It's already 12:29. I'm sorry. It was in between going here. So now I stop sharing. So here, I think I've exceeded by 15 minutes from an allotted time, but I can spend some more time to answer questions if it's agreeable to the participants.
Of course. Thank you, Dr. Jashwant. It was quite illuminating. I think there are a couple of questions, and one in the chat box is about whether Dr. Jashwantji, can we file a patent for research paper? I think you had already answered it, but the person would like to hear from.
Yeah, okay, let me look at research paper. See, research paper, I have just covered one example, how research paper was converted into a product or a process. So in your research paper, the work which you have done, so if it is abstract idea or some mathematical or algorithm, it cannot be. But if you convert all those into a new product or a new process of making some product, definitely that can be patented.
Mr. Kayal, you might want to paraphrase, give the question in the question and answers box. There are one from Mr. Avimanyu. I think
Yes, sir.
there is a long discourse, but get to the questions, which I think question number 2 and 3, those are the ones which are relevant.
Yes, sir. So the question number 2 by Mr. Abhimanyu is second law, about second law. Anyone can take part at any level of the project.
No, no, not that. No, not that. The question.
Okay.
Okay.
Go.
I'm not able to see the question.
Yes.
The question is farther way below that whether
Yes, sir.
international, because the initial thing is the discourse that he has provided.
Yes.
Okay.
Those are important things, but not relevant for this forum.
Yeah, tell me.
Instead of
Okay.
yes, sir. The question number 2.
So he said, okay, there will be no patent. Suggestions are best. Okay,
No,
even.
sir, Jashwantji, his question is, instead of filing a patent in India or US, is there an universal alternative to filing patents beyond
Okay,
borders?
okay. I'm now reached to that question. So well, let's.
No, that is the question. Previous ones are all he's making some points which are
Okay. See, there is nothing like global patent. Uh, Patent rights are granted by the government of that particular country. So this is granted right and not an automatic right. But it's unlike copyright. Once you have copyrighted in India, it's right is available to you in all the countries which are member of Berne Convention, and I think more than 180 countries are members. So once you've written a book in India, you have protection around the globe. But for patent, you have to file patent in that country where you seek protection. So if you file Indian patent, it will be valid in India, enforceable in India. If you file US patent, that will be valid in US, enforceable in US. So if you file patent in US, I can copy in India freely if you have not filed patent in India. But as an Indian citizen, we have to first file patent in India. But how we can have universal protection? So we have to go and file patent in each country. But this is a very difficult process to file patent in each country. To simplify that process, the World Intellectual Property Organization purported a treaty called Patent Cooperation Treaty, where you buy more time to file patent in all countries. So when you file patent in India, within 12 months, you can file PCT application. And the PCT system helps you in assessing patentability, both in terms of novelty, inventiveness, and legal patentable subject matter or not falling into non-patentable invention. So that is called an international application. So you can make an international application, and after 30 months, most of the country 30 months, in some country 31 months, you can go into national phase, and you can file patent in a specific country where you really need protection. But there is no universal or global protection available in the patents. Okay. You want to add to the question, then you can ask, switch on your mic. And
he has another question after that. How patents are applicable to intangible but scientific software?
And what are the difference with respect to copyright approach? See, copyright is not protecting your idea. Copyright is just protecting your literary or artistic work. So how your screen looks, that can be protected through copyright. Your source code, which you have written, your executive file, as if it is the same, it can be. But there are always ideas behind this software, what you achieve. Let's say you have a display, you're controlling a display. This all video platform is controlled by a software. It's an intangible scientific work. So now you can put all these videos together. All these this software, which platform Zoom has created, WebEx has created, it interact with your internet network, it interact with your camera, it interact with your mic, it interact with your computer system. It's an intangible thing. So this whole combination of interaction and providing you this platform is definitely a subject matter of patent. Now, when you say copyright, you have copyright on a source code of this particular software which Zoom has. But idea is putting these videos together. But if it is protected by copyright, tomorrow what I will come and write another program in another language, use another platform to achieve the same effect, then it's out of protection of that particular copyright. That idea is not protected of putting these videos together and having this platform. So that's the difference between copyright approach and patent approach. But copyright is available, author's life plus 60 year, patent protection is available for 20 years. So there's another difference in availability of a protection and approach. Right. So then there's no further questions. Ritesh Hajra has asked another question. What to do when status of patent application has been pending for too long time? See, your patent right that are not dependent fully on a grant of a patent. The patent right starts from date of publication of your patent application, but you can enforce rights of a grant. So you do all activities which you want to do after filing of patent application. And definitely you can claim damages from date of publication of patent document when it's granted. So nothing stops you doing your all activities relating to your invention, including commercialization, and you don't have to wait for the grant of patent. Yes, grant of patent used to take too longer time in this country. Now that is going to be reduced to bare minimum. And then statutory time for this thing is 24 months, because at least 6 months to be given to public to oppose the grant of patent. So if you have a normal course, 18-month publication for 6-month time to public. So 24 months is an usual time for grant of patent. But if you want to speed up the process, you pay early publication fees and you can reduce it to the 7 to 8 months. That's a theoretical time, but practically there's a queue in patent office for grant, and that's now being reduced. And in special categories have been carved out by Government of India in the form of startup, government labs, for expeditious grant is available where there is a real requirement of expeditious grant, and patent has been granted in 93 days after the filing of request for examination. So I don't think that is too long a time to really implement of your idea and compete with the grant of patent. So I think it would be very difficult for inventor to compete with this grant process now. There's another question. If there is a specific mechanism process available for the particular output, if we develop another simpler and cheaper machine process with the same output, is that machine process patentable? We here really need to understand what is the output. So if your output of production is some, let's say, some chemical substance, some composite material, then if that outcome is protected per se by a product patent, still you can have alternative process to make that protected item, and you can have a process patent on that. If the product patent, if product is not patented, if you come up with an alternative process, whether it's a cheaper or a costlier, it hardly matters. See, costlier may be more efficient. See, if your product, let's say some curcumin extract, and if you are able to achieve with the costlier product 100% or more purity than which is available in the market, costlier process can also be patentable for making the same product. So it's cheaper or costly is not in question. It is how we are meeting a public requirement in efficiency, in technological advancement, etc., etc., and then the quality of the product. If some process takes 5 hours to be produced, and if you reduce the time by costlier method by, let's say, half an hour, you are able to produce the product. That's a new improved process. If you use a catalyst in the process, just mere use of catalyst, it helps you in performing the same process at a lower temperature. From 500 degrees centigrade, you are able to perform the same process as 100 degrees centigrade. So that technical advance is definitely subject matter of. And then I would like to give here a simple example. Process is very, very important part. And I take you to your kitchen. If you want to heat uh, buttermilk, if you heat just like that, put on a pan, it will be spoiled. But if you stir it and heat it, after till boiling, if you stir it, so that process makes a hell lot of difference in performing. So each process parameter which results into something new, definitely always a subject matter of it. So if there's an add-on on this question, then I can take. Oh,
Thank
where?
you, sir.
Okay, so
Sir, if you please allow me, may I take one participant from the chat box and allow that
yeah,
participant to
please,
talk
please,
and
please,
ask a question?
please,
Yeah.
please.
Okay. Priyanka Das, ma'am, if you are there, please unmute yourself and ask the question directly.
By the time she joins, I can answer the Tohin Das. He asked where to look for the patent document for filed patents. See, there is ipindia.nic.in is official website of Indian Patent Office, where you can access all the patents granted in India from 1911 and all the patents filed after 2005, which have been granted or not granted. So the access to the complete document is available on official website for Indian patents. And another database prepared by European Patent Office called, which is available freely to all. This is worldwide.e-spacenet. I'll share the detail with Dr. Samazdar. So more than 100 country patents are available on that website, and that's freely accessible.
Yes.
Yeah.
Priyanka Das, are you there? If you are there, please unmute yourself. Or otherwise, we are going to, sir, what say? Because we are running out of time.
Yes.
Already
Let
it's
us proceed. Yes.
12:45.
Mhm.
Yes. Okay, sir. So we are bound with time, and now I would like to go to the next part of this.
I can answer. You say, how do I sell an idea without a patent? You can sell, but
Okay,
hundreds,
okay, yeah.
thousands of people will copy and it will not have any market value. So patent is not an essential ingredient to sell the idea, but it helps you in protecting from competition. That's all. So the patent is not an essential element, and it's not whether you should have a patent for selling document, the idea or a product. Okay. Yeah.
Okay.
So Sant, you can go ahead.
Yes, sir. Thank you, sir. Thank you for those beautiful answers. Now I would request Professor Dr. Shukhendra Samasda sir to give some concluding remarks and to sum up the session. Sir, please.
This was, to me, first and foremost, a lesson in communication. The central idea, what I got out of this, is care and caution. And the way Dr. Jashwant Dev Panwarji paced his presentation, it was the medium, as they say, the medium is the message. So the presentation is the message. We should never hurry about matters. We should be of utmost careful and cautious. So this is crucial. Point number two is actually writing patent is a specialized profession in itself. So as scientists or researchers or teachers, our objective is not, not the primary objective that we write the patents ourselves. The objective is to be able to think what is patentable and especially what not to do in unawares. For example, not publish. If you publish, it becomes very difficult to get the patent. And the other point, that is the third point, is it is preposterous basically thinking to write something which we have never read about. So reading patents, some samples are the first step to get an idea about what is to be included and what is not. So these are the three pods of my tripod of takeaway from today's session. And I thank Dr. Yashwantji for elucidating it so clearly. I thank University, MAKAUT, and the partner university, IUST. I thank the leadership of the universities. I thank all the team members, the tech support, and the panelists who have been here. And I would take a moment to thank especially our participants. And I'm doing it so because I received a call last evening from one of the participants. And that individual expressed how this FDP has been beneficial to him. So it touched my heart that, okay, we put in hours of effort. Our resource persons like Dr. Jashwantji has taken time out of his exceedingly busy schedule to use his own word. Has been entangled in too many things, yet he gave his word and kept his word. So when we get feedbacks like that, like the phone call that we received, I think all our efforts, most of it at least, has borne some fruit of some size to all the participants. I really appreciate that, because it is 12:50 now and I can see about 130 still logged in. So that is there. There are two points I would like to mention. Is one about JP Shaw Sahib indicated about A to Z. I was thinking of doing it, but I put an almost for two reasons. One is often there are unnoticed inadvertent mistakes. The other thing is initially there were two other points. One was about the abstract writing, the other was about making presentation. But I think those have been covered adequately in in the sessions that we have already had. So maybe we are inching towards from almost to perhaps complete. Then we would like to, in with the note of thanks, would like to let let the participants and know that if you find this helpful, our services and expertise, whatever we have, is available. You could contact us. You have the email address on the brochure as well as the abstract book, I think. One of the things that I feel good about is here we work as a unified team without borders. So especially in scientific and technical writing, this entire school of natural, applied, and social sciences, which has expertise in mathematics, physics, chemistry, as well as material science, as well as applied statistics and analytics, Then we are introducing applied psychology and applied economics. All this is under the umbrella of this school. And we work as a unified unit with the Center of Linguistics and the Language Lab. So this blending, this alloying has made a little bit of a brass out of copper and zinc. So if you think, and we believe, we could humbly say that we have some expertise in this area. If we could be of any service, this is our way. This is my way to thank you. I offer these services for your benefit. Thank you very much for your attendance.
Thank you, sir. Thank you. So we are left with one more session of this FDP in the afternoon, and we will be starting at 2:30, sharp at 2:30, and that will be the last session of this FDP. And in that session, we will be announcing all the details, all the proceedings after the FDP is over. So till then, stay tuned, and we are coming back at 2:30. Thank you.
Namaskar,
Thank you all.
Jaswantji. It was so good to see you. Someday, hopefully, we'll see each